A Court of Appeals decision yesterday changing the way Michigan's no-fault auto reform law will be applied to those who were injured prior to the bill being signed in 2019.
Our Michael Martin has been covering the impact the new law has on crash survivors and their access to medical care for the last year and a half. He is live in the newsroom to break down this update. Michael?
Jamie, Max, this is a published opinion released by our state appeals court yesterday. It legally changes how the no-fault auto reform law of 2019 applies to those who were injured prior to it being signed. Advocates for crash survivors have maintained that the new no-fault law has cut them off from vital medical services. And while the insurance industry says they plan to appeal this decision, it is a major milestone for those fighting for a change.
Our members are really overjoyed. But we're a bit cautious with what the implementation to roll back is going to be like.
When Michigan's no-fault auto insurance law changed in July of 2021, it substantially lowered the amount of money that insurance companies are required to reimburse local care providers for services like in-home caregivers and medical transportation. And it capped the number of hours that a family member can be paid as an in-home caregiver.
These folks have had their lives completely upended through absolutely no fault of their own.
Crash survivors, their caregivers, and loved ones have been showing up to the state capitol since the start of 2021, urging lawmakers to pass legislation that would guarantee them access to the benefits they were promised when they purchased and paid for no-fault policies.
Our people are dying.
Whole group in their office.
These people are all being...
And on Thursday, the Michigan Court of Appeals issued an opinion in a case brought by two crash survivors, saying that these changes should not apply to those who bought policies and were injured prior to the new law being signed in 2019.
They so needed a breath of air. They so needed a wee bit of relief. And this has given it to them, and they're even more fired up.
This means insurance companies must revert to the previous medical fee schedules that were in place for all 18,000 Michiganders who were getting no-fault benefits.
The first thing that the court held is that the legislature, in enacting this statute, did not intend for the limitations on care to be applied to those people who were injured before the law was changed. The second important holding is that the court said even if the legislature had intended to do that, that would not be legal because that would be an unconstitutional infringement of the Michigan's Constitution's provision of the Contracts Clause.
Aaron McDonough, the executive director of the Insurance Alliance of Michigan, released a statement after the ruling, saying in part,
"Today's ruling is truly a disappointment for Michigan families and small businesses because it threatens to roll back the progress we've made and to eradicate the savings drivers are experiencing since the 2019 bipartisan reforms took effect, with the purpose of reducing the high cost of auto insurance."
They say they will appeal the case to the Michigan Supreme Court.
I certainly hope that insurance companies will abide by this because it is the law. And whether you like the result or not, you are bound by it.
For those who have been fighting on the ground, they say this is only the beginning.
We're just going back to the drawing board and looking at the plans we have rolled out, figuring out what's going to work, what do we have to change.
And we're not stopping until this law is right for every Michigan citizen, not just those that are injured now.
So again, the insurance industry is planning to appeal this decision to the state Supreme Court, but they take cases at their own discretion. So if the state Supreme Court decides not to take the case up, then it will remain law. For now, live in the newsroom, Michael Martin, Fox 17 News.